voting on. To summarize, Madam Chair, we should not interfere with ongoing litigation, which may be unprecedented, and we should give this issue regular process in the Judiciary Committee. I oppose the amendment and urge my colleagues to defeat it, and I'll yield back the balance of my time.
Gentleman yields back the balance of his time. Gentleman from Michigan.
I'd like to yield to the distinguished gentleman from Massachusetts, Ed Markey of the Energy Committee. 1 minute.
Gentleman from Massachusetts recognized for 1 minute.
Thank you, Mr. Chairman. This amendment eliminates confusion regarding the deadline for filing patent term extensions under the Hatch-Waxman Act and provides the certainty needed to encourage critical medical research. It also promotes good government by ensuring that the Patent Office and the FDA adopt consistent interpretations of the very same statutory language. And finally, this amendment is consistent with the only court decision addressing this issue. The court stated that the interpretation that is reflected in this amendment, this is from the court, I quote, is consistent with the statute's text, structure, and purpose. Right now, America's next Lipitor or Prozac can be bottled up at the Patent Office and never made available because of uncertainty regarding the patent term extension process. In order to uncork American innovation and invention, we need a patent extension process that is clear, consistent, and fair. That's exactly what the Conyers Amendment does. It enjoys broad bipartisan support, and it confirms and clarifies existing law. It is cost neutral. I urge support for the amendment.
Gentleman from Michigan.
I yield my good friend, also from Massachusetts, Mr. Richard Neal, unfortunately, 75 seconds.
Thanks.
Gentleman from Massachusetts recognized
Thank you, Madam
for
Speaker.
75 seconds.
I understand Mr. Smith's position here, but the truth is that when he suggests that we're doing things that are interfering with ongoing court tests, there have been a series of votes here already about the health care law and guaranteed to have more coming in this institution. So I'm not going to spend a lot of time on that suggestion, but I rise today in support of the amendment. It addresses the deadline for filing patent term extension applications under Hatch-Waxman. By adopting a clear standard, the amendment would provide the opportunity and certainty needed to allow innovators to conduct time-consuming, expensive medical research necessary to bring new life-saving drugs to market. The amendment clarifies the law in a manner that tracks the only court decision to have addressed this particular provision. It will ensure that all applications in all cases are treated the same. Because the amendment merely confirms the existing law, it is budget neutral. The amendment enjoys broad support on both sides of the aisle. I hope that my colleagues will join me in supporting it.
Gentleman from Michigan.
Madam Speaker, I am proud now to recognize Mike Pompeo, the distinguished gentleman from Kansas, for 30 seconds.
Gentleman from Kansas recognized for 30 seconds.
Great, thank you. I rise in support of this amendment as a former business owner. Compliance with senseless government regulations was one of my biggest frustrations, and honestly one of the reasons I ran for Congress. But it's impossible to comply with regulations when you get two different interpretations from two different agencies, and that's what we have here with this intellectual property rule. The PTO and the FDA have established two different standards, and this amendment simply seeks to fix that, to give an identical outcome from two different agencies that resulted from different interpretations of the Hatch-Waxman Act of 1984. Inventors shouldn't have to guess. We can put a clean deadline. I rise and urge my colleagues to support this amendment.
Gentleman from Michigan has 45 seconds remaining.
I yield all the rest of my time to Scott Garrett, the distinguished gentleman from New Jersey.
Gentleman from New Jersey is recognized for the remaining time.
Mr. Chairman, the Hatch-Waxman Act provides for the extension of patent terms covering drugs products that must be approved by the FDA. And with the extension that we're talking about here, while seemingly straightforward, the Patent Office and the FDA have interpreted it, as we said, in two different ways, creating uncertainty that have led to miscalculation. And so our amendment is consistent with a court ruling which will clarify that when the FDA provides final approval after normal business hours, that 60-day clock begins on the next day. And so by doing this, by ensuring that patent holders will not lose their rights prematurely, what this amendment does will not only resolve a long-standing problem, but will encourage the development of innovative new drugs as well. And with that, I urge the adoption of this very common-sense amendment, and I do yield back.
All time has expired. The question is on the amendment offered by the gentleman from Michigan. Those in favor say aye. Aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not
Madam
agreed to.
Speaker, may I have a record vote?
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Michigan will be postponed. It is now in order to consider Amendment Number 10, printed in Part B of House Report 112-111. For what purpose does the gentlewoman from California seek recognition?
Madam Chair, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment number 10, printed in Part B of House Report number 112-111, offered by Ms. Spear of California.
Pursuant to House Resolution 316, the gentlewoman from California, Ms. Spear, and a member opposed, each will control 5 minutes. The chair recognizes the gentlewoman from California.
Madam Chair, thank you. My amendment enhances the derivation proceedings provision in the first inventor to file section of the bill. As we know, the U.S. Patent Office is a vital tool that facilitates universities and businesses of all sizes to turn ideas and discoveries into successful products. Having said that, we must ensure that our patent system provides strong and predictable intellectual property protections. This Act creates a new process called derivation, by which a party can defeat an earlier filed patent application by showing that the invention in the earlier application was derived from the party's invention or concept. The bill requires a party to support a petition for derivation by, quote, substantial evidence in order to initiate a proceeding. The derivation proceedings in this legislation must be a process that is fair, reliable, and permits the Patent and Trademark Office to make a decision based on solid record of relevant evidence. This amendment helps to accomplish this by requiring the PTO to provide rules for the exchange of relevant information by both parties. The substantial evidence threshold at the petition stage of the proceedings may not be reasonable in some circumstances. For example, consider a situation where an inventor discloses an invention to a venture capitalist who declines to invest in it. The venture capitalist has conversations with several other VCs about the invention, and eventually a company funded by one of those VCs files a patent application for something very much like the original invention. If a company funded by the original VC has filed the application, the inventor would be able to show substantial evidence of derivation through the disclosure to the VC and the link between the VC and the company filing the application. However, in the instance when an inventor did not personally make a disclosure to other VCs or the company that filed an application, it would be difficult for the inventor to show substantial evidence, particularly relevant disclosures about which the inventor is unaware. The public's interest in fostering innovation requires that the derivation proceedings be equitable to both parties and that the PTO have a complete record of evidence on which to make its decision. Inventors must have a fair chance to prove their claim, and defending parties must be able to provide evidence to rebut claims. This amendment accomplishes these goals by requiring the PTO to provide rules for the exchange of relevant information and evidence by both parties. Madam Chair, I reserve the balance of my time.
The gentlewoman reserves the balance of her time. Gentleman from Texas.
Madam Chair, I claim the time in opposition, but I support the amendment.
Without objection, the gentleman is recognized.
Madam Chair, I think this is a good amendment. I urge my colleagues to support it. Now yield back the balance of my time.
Gentleman yields back. Gentlewoman from California.
I yield whatever time I have remaining to the gentleman from Maryland, Mr. Hoyer.
Gentleman from Maryland is recognized for 2.5 minutes.
Thank you very much, Madam Chair. Thank you for yielding. I rise in support of this legislation. I am a strong supporter, as many of you know, of what we call our Make It in America agenda. Make It in America simply means that we're going to provide jobs, we're going to provide opportunities, and we're going to build the manufacturing sector of our economy. In order to do that, we also need to enhance the inventive, innovative, and development phases of our economy. This bill, I think, will facilitate this. I congratulate the gentlelady from California for this amendment as well, which I think improves this bill. And I rise in strong support and urge my colleagues to support this piece of legislation. I congratulate all of those who have worked on this legislation. It is obviously not perfect, but then again, no piece of legislation that we adopt is perfect. It is, however, a significant step forward to make sure that America remains the inventive, innovative development capital of the world. In order to do that, we need to manufacture goods here in America. Manufacture the goods that we invent, innovate, and develop. Because if we continue to take them to scale overseas, then the inventors, innovators, and developers will themselves move overseas. So I thank Mr. Smith, I thank Mr. Watt, I thank others who have worked so hard on this legislation, Ms. Lofgren as well, who have dedicated themselves to trying to make sure that we have a context and an environment in America which will facilitate the inventive, innovative sector of our economy. And I yield back the balance of my time.
Gentleman yields back. All time has been yielded back. The question is on the amendment offered by the gentlewoman from California. Those in favor say aye. Those opposed, no. In the opinion of the chair, the ayes have it. The amendment is agreed to. It is now in order to consider amendment number 11, printed in Part B of House Report 112-111. For what purpose does the gentlewoman from California seek recognition? Does the gentleman from North Carolina seek recognition?
Madam Chair, we were expecting Congresswoman Waters. I would ask unanimous consent that this amendment be delayed until we can determine whether she's still planning to offer it.
Committee of the Whole is unable to reorder the amendments.
All right. In that case, I will ask unanimous consent to offer the amendment in her stead.
Is a designee of the gentlewoman from California.
Yes.
Qualifies for the clerk will designate the amendment.
Amendment number 11, printed in Part B of House Report number 112-111, offered by Mr. Watt of North Carolina.
Pursuant to House Resolution 316, the gentleman from North Carolina, Mr. Watt, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from North Carolina.
Thank you, Madam Chair. I yield myself as much time as I may consume solely to say that this is a straightforward amendment that provides that if one part of the bill is determined to be unconstitutional, it can be severable from the rest of the bill and it doesn't bring the rest of the provisions down. That's a standard policy to put in most legislation, and with that, I reserve the balance of my time.
Gentleman reserves the balance of his time. Gentleman from Texas.
Madam Chair, I rise to claim the time in opposition, although I support the amendment.
Unanimous consent. The gentleman is recognized.
Okay. Madam Chair, I thank the gentleman for offering the amendment. I urge my colleagues to support it, and I'll yield back the balance of my time.
Gentleman yields back. Gentleman from North Carolina.
I've just been advised that we were mistaken in the desire of Ms. Waters to offer the amendment, so that she didn't want me to offer it in her stead, and that's why she didn't show up. So I'm not sure what the appropriate procedure is to. I would just ask unanimous consent to withdraw the amendment unless the chair has objection.
Without objection, the amendment is withdrawn.
Okay.
It is now in order to consider amendment number 12, printed in Part B of House Report 112-111. For what purpose does the gentleman from Wisconsin seek recognition?
Madam Chair, I have an amendment at the desk made in order under the rule.
The clerk will designate the amendment.
Amendment number 12, printed in Part B of House Report number 112-111, offered by Mr. Sensenbrenner of Wisconsin.
Pursuant to House Resolution 316, the gentleman from Wisconsin, Mr. Sensenbrenner, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Wisconsin.
Madam Chair, I yield myself a minute and a half.
The gentleman is recognized for a minute and a half.
Madam Chair, Section 3 of this bill creates a first-to-file patent system. The sponsors believe that the United States should harmonize with other countries' first-to-file system. There's no reason to do that. Our patent system is the strongest in the world, and it's based upon the first recognition of the Constitution in any country that inventors should be protected. I think that the Constitution empowers Congress to give patents only to inventors. We had a significant constitutional argument on this issue yesterday. If the amendment is not adopted, the issue will be litigated all the way up to the Supreme Court. The current first-to-invent system has been key in encouraging entrepreneurial innovation and evens the playing field for individual inventors who are not represented by a major industry. The first inventor-to-file system violates the Constitution because it would award a patent to the winner of the race to the PTO and not the actual inventor who makes the first discovery. If we change to a first-to-file system, inventors who believe they do not have sufficient resources to win the race to the PTO will not have any motivation at all to continue developing the new invention. This will stifle innovation, and given the current state of our economy, that's the last thing we need. I yield myself an additional 15 seconds.
Gentleman's recognized.
First to file also invites excessive filings and will add to the burden of the USPTO by increasing the examiner's workload. We already have financing problems there. If this amendment is not adopted, it will be worse. I reserve the balance of my time.
Gentleman reserves. Gentleman from Texas.
I claim the time in opposition.
Gentleman's recognized for 5 minutes.
Madam Chair, the gentleman's amendment strikes the first inventor-to-file provisions from the bill. I strongly oppose the amendment. The move to a first inventor-to-file system creates a more efficient and reliable patent system that benefits all inventors, including independent inventors. This provision provides a more transparent and certain grace period, a key feature of U.S. law, and a more definite filing date that enables inventors to promote, fund, and market their technology while making them less vulnerable to costly patent challenges that disadvantage independent inventors. The first inventor-to-file system is absolutely consistent with the Constitution's requirement that patents be awarded to the inventor. Former Attorney General Michael Mukasey has stated that the, quote, provision is constitutional and helps assure that the patent laws of this country accomplish the goals set forth in the Constitution to promote the progress of science and useful arts, end quote. Under first inventor-to-file, patent rights are reserved to someone who independently conceived of an invention before it was in the public domain. And under the Constitution, that is what is required to be considered an inventor. In fact, early American patent law, that of our founders' generation, did not concern itself with who was the first to invent. The U.S. operated under a first inventor-to-register system for nearly half a century, starting in 1790. The first inventor-to-register system is similar to first inventor-to-file, a system that the founders themselves supported early in our nation's history. The courts did not even concern themselves with who was the first person to invent until 1870 with the creation of interference proceedings. Those proceedings are the ones that disadvantage independent inventors and small businesses. And over the years, and in subsequent revisions of the law, those proceedings have morphed into a costly litigation tactic. Under first inventor-to-file, an inventor submits an application to the Patent Office that describes their invention and how to make it. That, along with just a $110 fee, gets them a provisional application and preserves their filing date. This allows the inventor an entire year to complete the application while retaining the earlier filing date. By contrast, the cost of an interference proceeding in today's law could run an inventor $500,000. Accusations that the bill doesn't preserve the one-year grace period are simply false. This bill provides a stronger, more transparent, and certain one-year grace period for disclosures. This enhances protection for inventors who have made a public or private disclosure of their invention during the grace period. The grace period protects the ability of an inventor to discuss or write about their ideas for a patent up to 1 year before they file for patent protection. These simple requirements create a priority date that is fixed and public so that everyone in the world can measure the patent against competing applications and patents and relevant prior art. In addition, many inventors also want protection for their patents outside the United States. If you plan on selling your product overseas, you need to secure an early filing date. If you don't have a clear filing date, you can be shut out from the overseas market. A change to a first inventor-to-file system will help our businesses grow and ensure that American goods and services will be available in markets across the globe. The current first-to-invent system seriously disadvantages small businesses and independent inventors. Former PTO Commissioner Gerald Mossinghoff conducted a study that proves smaller entities are disadvantaged in PTO interference proceedings that arise from disputes over patent ownership under the current system. In the last 7 years, only one independent inventor out of 3 million patent applications filed has proved an earlier date of invention than the inventor who filed first. Madam Chair, let me repeat that. In the last 7 days, only one independent inventor out of 3 million patent applications filed has proved an earlier date of invention than the inventor who filed first. Independent inventors lose to other applicants with deeper pockets that are better equipped to exploit the current complex legal environment. So the first inventor to file change makes it easier and less complicated for U.S. inventors to secure their patent rights, and it protects their patents overseas. And it eliminates the legal bills that come with interference proceedings under the current system. It is a key provision of this bill. Madam Chair, the amendment should not be approved, and I urge my colleagues to vote against it, and I'll yield back the balance of my time.
This time, gentleman from Wisconsin.
Yield a minute to the gentleman from California, Mr. Schiff.
Gentleman from California is recognized for 1 minute.
I thank the gentleman for yielding, and I find myself in reluctant opposition to my colleague from Texas in support of the Sensenbrenner amendment. Section 3 shifts our patent system from the unique first-to-invent system to a first-to-file system. As I speak to inventors, startups, venture capitalists, and angel investors in California, I'm convinced that the proposed transition to first-to-file would be harmful to innovation and burdensome to the most dynamic and innovative sector of our economy. With the shift to first-to-file, the rush to the patent office will lead to new costs for small businesses as they prepare applications for inventions that may ultimately find impractical. For small startups, the cost of retaining outside counsel for this purpose will be a drain on their limited resources and mean less money for hiring any actual active innovation. Supporters of first-to-file argue inventors can turn to provisional applications to protect their patent rights, but from talking to small inventors, I have learned that good provisional applications require substantial legal fees and time investment on the part of the inventor to make them sufficiently detailed to be of use. I appreciate the hard work, but
another 15 seconds.
I appreciate the hard work that has gone into the bill by the gentleman from Texas. However, I remain deeply concerned that the shift to first-to-file will have lasting negative consequences for small investors, and I urge the House to improve the bill by adopting the Sensenbrenner amendment. I yield back.
Gentleman yields back.
Madam Chair, I yield a minute to the gentlewoman from California, Ms. Lofgren.
Gentlewoman from California is recognized for 1 minute.
Thank you, Madam Chair. I rise in support of the Sensenbrenner amendment. Actually, I don't agree that first-to-file is unconstitutional, and I, in general, am not opposed to the idea of first-to-file, but unfortunately, the bill is flawed, and you cannot have first-to-file without robust prior user rights and a broad prior user rights used in the grace period. We don't have that in this bill. And so what we will have are established businesses having to either reveal trade secrets or be held up, to have to license their own trade secrets. For startups, this is a very serious problem. And coming from Silicon Valley, I'll tell you, I've heard from a lot of startups and the venture world that supports them that this provision is defective. There were other remedies. They were not adopted. All we can do now is to strike the first-to-file provision. I do that without any reluctance. It will serve our economy best, and I thank the gentleman for offering his amendment.
The gentleman from Wisconsin has 1 minute remaining.
Madam Chair, I yield myself the balance of the time.
The gentleman is recognized.
Madam Chair, the reason that first to invent is important is that it allows an inventor to talk to investors, conduct trial and error innovation, and deal with leaks because commercially important patent rights are determined by ordinary, non-burdensome business activities. Where this hurts the ordinary inventor by going to first to file is that he needs to get his venture capital together and then go ahead and file for a patent. With first to file, he has to put all of the money up front to file in order to protect himself. And what that will do is have a chilling effect on the small inventor who needs to get capital in order to perfect a patent and in order to market it. That's why this amendment should be adopted. I urge the members to do so, and I yield back the balance of my time.
The gentleman yields back. The question is on the amendment offered by the gentleman from Wisconsin. Those in favor say aye. Those opposed, no. The opinion of the chair, the noes have it. The amendment is not agreed to.
I ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from Wisconsin will be postponed. It is now in order to consider Amendment Number 13, printed in Part B of House Report 112-111. For what purpose does the gentleman from Illinois seek recognition?
Amendment at the desk.
The clerk will designate the amendment.
Amendment number 13, printed in Part B of House Report number 112-111, offered by Mr. Manzullo of Illinois.
Pursuant to House Resolution 316, the gentleman from Illinois, Mr. Manzullo, and a member opposed, each will control 5 minutes. The gentleman from Illinois is recognized for 5 minutes.
Madam Chair, there are a lot of problems with this bill, as we have heard about already. In fact, on the wall of my office here in Washington, I have 2 pictures, among many. One is a picture of W. Edwards Deming and myself taken just before he passed away in 1993, the real inventor of lean manufacturing. The other of Dr. Ray Damadian, the inventor of the MRI, who, when examining this legislation, said if the new changes had taken place in the patent law, had they been part of the patent system, when he invented the MRI never would have been invented. He knows more than anybody how flawed this bill is. I want to focus in particular on Section 10 of the bill, which allows the Director of the Patent Office to set fees. I'm very concerned about this because in the last patent fight in 2004, when I chaired the House Small Business Committee, in return for supporting higher fees with reduced rate structure for small businesses, the provision in that bill allowing the PTO director to set fees was removed. This new bill abrogates that hard-won compromise and allows the director of the PTO to set the fees. It is not wise for the legislative branch to give up more power and authority to the executive branch. I know it's inconvenient to have Congress set fees, but that's the job of Congress, not the job of an unelected bureaucrat. When I chaired the House Small Business Committee, I continued the tradition of preventing the SBA from unilaterally being able to set fees to whatever level they sought. I don't see why we have to do this with the PTO. Now, in the present bill, Section 11 actually lowers fees for small business people and has a good patent fee structure. However, Section 10 would allow the PTO director to proceed with the administrative process to eviscerate that section and impose his own fees. To compound the problem, the Patent Office has been saying for years that if they had the authority to raise fees, they would. In 2002, the PTO strategic plan said they need to have a fee based upon a progressive system aimed at limiting applications. In 2010, the white paper on patent reform, they said the same thing. The Patent Office's idea of cutting back on the backlog is to raise fees. That doesn't make sense. But let's eliminate that authority from the Patent Office. Let's leave that authority with the United States Congress. And I reserve the rest of my time.
Gentleman reserves the balance of his time. Gentleman from Texas.
Madam Chair, I rise in opposition to the amendment.
Gentleman's recognized for 5 minutes.
Madam Chair, I oppose the gentleman's amendment to strike the PTO fee-setting authority from H.R. 1249. Although the PTO has the ability to set certain fees by regulation, most fees are set by Congress. History has shown that such a scheme does not allow the PTO to respond to the challenges that confront it. The PTO, most stakeholders, and the Judiciary Committee have argued for years that the agency must have fee-setting authority to address its growing workload. This need is critical. The agency's backlog exceeds 1 million patent applications. This means it takes 3 years to get a patent in the United States, far too long. The wasted time leads to lost commercial opportunities, fewer jobs, and fewer new products for American consumers. Moreover, the new fee structure will not only retain the existing 50% discount for small businesses, it creates a new 75% discount for micro entities. This benefit helps independent inventors and small businesses. The bill allows the PTO to set or adjust all of its fees, including those related to patents and trademarks, so long as they do no more than reasonably compensate the agency for the services performed. To the charge that we are abandoning our oversight of the process, I urge the members to review the oversight mechanisms in the bill. For example, prior to setting such fees, the Director must give notice to and receive input from the Patent or Trademark Public Advisory Committee. The Director may also reduce fees for any given fiscal year, but only after consultation with the advisory committees. The bill details the procedures for how the Director shall consult with the advisory committees, which includes providing for public hearings and the dissemination to the public of any recommendations made by either advisory committee. Fees shall be prescribed by rule. Any proposed fee change shall be published in the Federal Register and include the specific rationale and purpose for the proposed change. The Director must seek public comments for no less than 45 days. The Director must also notify Congress of any final decision regarding proposed fees. Congress shall have no more than 45 days to consider and comment on any proposed fee, but no proposed fee shall be effective prior to the expiration of this 45-day period. Congress will remain part of the process, but PTO is better able to respond to their own resource needs, which, after all, will benefit patent holders and subsequently the economy. So I urge my colleagues to oppose the amendment, and Madam Chair, I'll yield the balance of my time to the gentleman from Virginia, the Chairman of the Intellectual Property Subcommittee, Mr. Goodlatte.
The gentleman from Virginia is recognized for 2.5 minutes.
I thank the Chairman for yielding, and Madam Chairman, I rise in opposition to this amendment. The Senate-passed patent bill granted the PTO fee-setting authority into perpetuity. The Senate's goal was laudable. It wanted to allow the PTO to have control over the fees it charges so that it would have more certainty about rolling out new programs and hiring new examiners to deal with pendency and quality issues. We have, as you know, a very long backlog, 3 years, 1 million patents. However, I had strong concerns with granting this much authority to a government agency. Currently, the PTO must come before Congress to request any fee increases. This forces the PTO to use its current resources in the most efficient manner and also strengthens Congress' hand when it comes to oversight over the agency. Thus, I worked to get a provision into the House bill that would sunset the PTO's fee-setting authority. The bill now terminates the fee-setting authority after 7 years unless Congress proactively acts to extend it. This will allow the PTO sufficient time to structure its fees, but will ensure that Congress continues to have a strong influence over that process. And I might add that the manager's amendment to the bill also strengthens Congress' hand and limits the objective of the PTO to arbitrarily raise its fees because the Congress still appropriates the funds and can only escrow funds, can't divert them to another purpose, but escrows them. PTO will have to come back to the Congress and justify additional funds that it receives. I believe the bill, as it is written right now, strikes the right balance, and I urge members to oppose this amendment, which would altogether eliminate PTO fee-setting authority.
Gentleman from Illinois.
Madam Chair, you don't strike a right balance between an inventor's constitutional right to file for an invention and giving a patent czar the authority to keep him out of the box by allowing him to raise the fees. Mr. Smith from Texas said it himself. He coupled patent backlog with the ability of the patent director to set the fees. That could only lead to one conclusion. They're going to raise the fees in order to cut down on the patent backlog. It doesn't make sense. This is the people's house. The patent office is the people's house for the little inventor. He must have every opportunity to exercise his constitutional right and file that patent. But if Congress cedes the authority to set those fees to a new authority of the patent director, and we can call him now the patent czar, that patent czar will control for 7 years, at the minimum, the flow of traffic coming through his office. And do you know who gets slowed? Do you know who gets hurt? It's the little guy. And the purpose of my amendment is to protect the little guy, to make sure those fees are not raised, and also to make sure that the people in this country elect representatives in Congress, because it's our job to set the fees, not the fees of an unelected person, the person in charge of the Patent Office. I would therefore urge my colleagues to vote for the Manzullo Amendment, to support the little inventor, to support the spirit of entrepreneurship in this country.
Does the gentleman yield back? Remaining
I yield
time.
back.
Gentleman yields back. The question is on the amendment offered by the gentleman from Illinois. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to.
Madam Chair, I request a recorded vote.
Pursuant to Clause 6 of the Rule 18, further proceedings on the amendment offered by the gentleman from Illinois will be postponed. It is now in order to consider Amendment Number 14, printed in Part B of House Report 112-111. For what purpose does the gentleman from California seek recognition?
I have an amendment at the desk.
The clerk will designate the amendment.
Amendment number 14, printed in Part B of House Report number 112-111, offered by Mr. Rohrabacher of California.
Pursuant to House Resolution 316, the gentleman from California, Mr. Rohrabacher, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from California.
Thank you very much. In this debate, Madam Chairman, we have heard over and over and over again about the gridlock at the Patent Office, which is supposedly what we're trying to correct with this legislation, H.R. 1249, which I have been contending is not designed to help the Patent Office, but to harmonize American law with the rest of the world and make it weaker patent protection for our people. Well, what does it do about the backlog if that's really what people are concerned about? H.R. 1249 would actually tremendously add to the PTO backlog by requiring further post-grant review proceedings at the Patent Office, proceedings which would consume even more limited personnel and money. Added procedures add to the gridlock at the PTO, at the Patent Office, and it will also do what? It will break the back of small inventors and startup companies who are trying to get a new product on the market. It will empower the multinational and foreign corporations who can grind down the little guy, because what we're doing in this bill is adding even further procedures they have to go through even after they've got their patent issued to them. This is the big guy versus little guy legislation. That was even pointed out by the Hoover Institution, which did an analysis of this bill and said, and I quote, "The American Invents Act will protect large entrenched companies at the expense of market-challenging competitors." End of quote. This is a travesty. It's an attack on American well-being, because we depend on our small inventors to come up with the ideas. The Captain Rohrabacher amendment limits this new burden. If we can't get rid of it, at least we can limit this new burden of all these post-grant reviews they're going to add to companies that have more than 100 employees. It frees up the Patent Office personnel to do their job, helps with that gridlock, and protects the small businessman and small inventors at the same time. I would ask my colleagues to support the Captain Rohrabacher amendment and yield the balance of my time to Ms. Capter. Which is how long, could I inquire?
Gentlewoman from Ohio is recognized for 2 3/4 minutes.
I thank the gentleman, Mr. Rohrabacher, for yielding, and urge my colleagues to support the Rohrabacher-Kaptur amendment, which ensures fairness for small and independent inventors. Without it, this bill will destroy American job creation and innovation, since it throws out 220 years of patent protections for individual inventors. Our amendment addresses a major shortcoming of the bill by eliminating the burden of post-grant reviews and reexaminations on individual inventors and small businesses with 100 or fewer employees. The new procedures and regulations in this bill will make it extremely difficult for the average citizen to ever get a patent or defend one without our amendment. Our amendment clearly gives the Patent Office the authority to issue appropriate regulations that ensure that the new regulatory burdens on this bill do not disproportionately impact individual inventors. This amendment is about ensuring fairness for small inventors. We urge our colleagues to support the Kaptur-Rohrabacher amendment so all inventors in America have a chance to realize their dreams. And in realizing their dreams, assuring that we will have robust innovation and job creation in our country. And I'd like to yield back my remaining time to the fine gentleman from California.
And how much time is left, Madam Chairman?
Gentleman from California has 1.5 minutes remaining.
1.5 minutes. Thank you. Let me just note, this amendment our amendment empowers the Director of the Patent Office to extend this 100-employee standard to other small businesses and individual inventors overseas. If this is required by a treaty, yes, small businesses and individual inventors overseas. So our amendment does nothing to violate any treaty obligations by giving our own people special rights over foreign individuals. What it does do, however, is prevent foreign corporations from grinding down our inventors here like they grind down their inventors overseas. This is what we're doing to prevent a harmonization of our laws, because we don't want weaker patent protection for our people against, they've already got it overseas against their foreign corporations that grind them down. We want to protect our own people, and I reserve the balance of my time.
Gentleman reserves the balance of his time. Gentleman from Texas.
Madam Chair, I rise in opposition to the amendment.
Gentleman is recognized.
Madam Chair, almost everyone in Congress wants to help small businesses. They are the foundation of our economy and are the primary job creators. But this amendment includes certain terms or phrases that have nothing to do with the underlying goal that it purports to achieve. This amendment appears to focus on small businesses, but in reality, the amendment attempts to provide the trial lawyer, lobby, and patent trolls with an exemption from PTO reexamination, allowing them to continue suing job creators using frivolous or questionable patents. This amendment has nothing to do with small businesses and everything to do with providing an exemption for some of the worst offenders of our patent system. This amendment will not help independent inventors or small businesses. Small businesses need the PTO reexamination proceedings. Those proceedings strengthen patents, and strong patents are what investors look for when making decisions about whether or not to provide venture capital funding. The argument that reexam proceedings harass or hurt small businesses is just plain wrong. The reexam proceedings are a cheaper, quicker, better alternative to resolve questions of patentability than costly litigation in federal court, which can run into the millions of dollars and last for years. This amendment is an immunity agreement for patent trolls, those entities who do not create jobs or innovation, but simply game the legal system. Additionally, this amendment appears to violate our international obligations under the TRIPS agreement. Under TRIPS, we are obligated not to discriminate against any field of technology or categories of patent holders. By providing an exemption from all reexamination proceedings for technological patents granted to patent trolls or non-practicing entities, this would create a clear violation of our legal obligations. Our patent system should be designed to ensure that it produces strong patents and patent certainty. The PTO reexamination proceedings help ensure that these important goals are accomplished. This amendment bars any form of reexam for U.S.-owned patents, and thus would also prevent U.S. inventors themselves from using supplemental examination to even be able to correct errors in the record about their own patents. This amendment creates a huge loophole in our patent system by exempting entities with 100 or fewer employees. This will not help small businesses, but will allow patent troll entities, foreign companies, and foreign governments to manipulate our patent system. It would bar use of the business methods transitional proceeding against most business method patents. This amendment is a recipe for allowing patent trolls and foreign companies and their governments to bypass normal post-grant challenges and enables weak or questionable patents to bypass further scrutiny. There is no legitimate public policy objective in exempting large numbers of those who manipulate our patent system from the rules of the road. It is for these reasons that I strongly oppose this amendment. And, Madam Chair, I'll now yield the balance of my time to the gentleman from Virginia, Mr. Goodlatte.
Gentleman from Virginia is recognized for 2 minutes.
Madam Chairman, I rise in strong opposition to this amendment, which is a bad idea. The post-grant review is one of the most important provisions in this bill. It allows third parties, for a limited window of 9 months after a patent is issued, to submit evidence that the patent should not have been granted in the first place. This allows third parties, many of whom will be small businesses themselves who are familiar with the subject matter, to provide a check on patent examiners. If the evidence shows that the patent is indeed invalid, then the patent applicant should never have received the patent in the first place. If the evidence shows that the patent is valid, then the patent is made stronger and more certain by surviving a post-grant review. The amendment would exempt small businesses from the post-grant opposition proceeding. However, the quality of a patent examination does not hinge on the size of the applicant, whether it was a small business, an independent inventor, or a large corporation. It hinges on the PTO's job of scrutinizing that patent. A bogus patent held by an independent inventor is no less deserving of a second look than a bogus patent held by a Fortune 500 company. For these reasons, I urge opposition to this very bad amendment. And I reserve the balance of the...
I'll yield back the balance of my
Gentleman
time.
yields back. Gentleman from California has 30 seconds remaining.
I would yield the balance of my time, Ms. Capter.
Gentlewoman from Ohio is recognized for 30 seconds.
Yes, I would like to refute Mr. Smith's argument. In fact, he's manufactured an argument against our amendment that says it will violate WTO obligations, specifically citing TRIPS. He seems to object to the use of references to American citizens and U.S. companies, but obviously failed to read the entire amendment, which allows the Patent Office to issue relevant regulations for properly implementing this amendment. And if he was so concerned about WTO compliance, he should strike Section 18 of his own bill, which is clearly WTO non-compliant because it creates a special class for only one industry, the banking industry. I urge my colleagues to vote against the bill and for the Rohrabacher-Kaptur amendment.
All time has expired. The question is on the amendment offered by the gentleman from California. Those in favor say aye. Those opposed say no. In the opinion of the chair, the noes have it. The amendment is not agreed to.
I would ask for a recorded vote.
Pursuant to Clause 6 of Rule 18, further proceedings on the amendment offered by the gentleman from California will be postponed. It is now in order to consider Amendment Number 15, printed in Part B of House Report 112-111. For what purpose does the gentleman from Illinois rise?
Thank you, Madam Chairwoman. I have an amendment at the desk.
Clerk will designate the amendment.
15, printed in Part B of House Report Number 112-111, offered by Mr. Schock of Illinois.
Pursuant to House Resolution 316, the gentleman from Illinois, Mr. Schock, and a member opposed, each will control 5 minutes. The chair recognizes the gentleman from Illinois.
Thank you, Madam Chairwoman. Well, I thought when we started this Congress that we had agreed to no more earmarks, no more handouts, no more special privileges for any specific industry. But based on reading House Resolution 1249, it's obvious to see that it includes controversial language, which does just that. Section 18, which sets forward a new and different process for certain business method patents for any other patent seeking approval. Section 18 carves out a niche of business method patents covering technology used specifically in the financial industry and would create a special class of patents in the financial services field subject to their own distinctive post-grant administrative review. This new process allows for retroactive reviews of already proven patents that have undergone initial scrutiny, review, and have even been upheld in court. Now these patents will be subjected to an unprecedented new level of interrogation. Now the other side will argue that somehow magically a number of these financially related patents breeze through the Patent Office and thus must be reviewed. Well, nothing could be further from the truth. In fact, the allowance rate for these business method patents is the smallest of any of the art forms. In fact, roughly 10% of those business method patents applied for are actually approved. At a time when these small entrepreneurs and innovators need to be dedicating their resources and new advancements to innovation, they will instead, because of Section 18, be required to divert research funds to lawyers to fight the deep pockets of Wall Street, who will now attempt to attack their right to hold these financially related patents. With that, Madam Chair, I would reserve the balance of my time.
Gentleman reserves the balance of his time. Gentleman from Texas.
Madam Chair, I claim the time in opposition to this amendment.
Gentleman's recognized for 5 minutes.
Madam Chair, let me yield myself 1 minute.
Gentleman's recognized for 1 minute.
Madam Chair, I strongly oppose this amendment. It strikes a useful provision that would provide a way to review the validity of certain business method patents. The proceeding would create an inexpensive and faster alternative to litigation, allowing parties to resolve their disputes rather than spending millions of dollars that litigation now costs. In the process, the proceeding would also prevent nuisance or extortion lawsuits. This provision is strongly supported by community banks, credit unions, and other institutions that are an important source of lending to homeowners and small businesses. Finally, this bill only creates a new mechanism for reviewing the validity of business method patents. It does not alter the validity of those patents. Under settled precedent, the transitional review program is absolutely constitutional. Madam Chair, I'll now yield 1 minute to the gentleman from New York, Mr. Grimm, who is a member of the Financial Services Committee.
Gentleman from New York is recognized for 1 minute.
Thank you, Madam Chairman. I rise today to call on my colleagues to oppose the Shock Waters Amendment. This amendment would strike one of the legislation's most important reforms, a crackdown on low-quality business method patents, which have weakened the patent system and cost companies and their customers millions of dollars. Infamous patent trolls, people who aggressively try to enforce patents through courts and friendly venues, have made business method patents their specialty in recent years. These same patent trolls have funded an elaborate propaganda campaign targeting the reforms in Section 18. Let us simply set the record straight. Section 18 allows patent experts to re-examine through temporary pilot programs legally questionable business method patents, a problem that the Patent Office has already said it is ready and willing to tackle. Opponents have asserted that the measure would help only the banks. This isn't true. National Retail Federation and the U.S. Chamber of Commerce have endorsed this provision. Companies impacted include McDonald's, Walmart, Costco, Home Depot, Best Buy, and Lowe's. These don't sound like banks to me. Opponents also claim that this section is unconstitutional.
Madam Chair, I'll yield the gentleman an additional 15 seconds.
Gentleman's recognized another additional 15 seconds.
Thank you. Again, there has been a tremendous propaganda campaign basically to sell untruths that we simply need to get past. The truth is, this is best for the small guy. If we really care about the small inventors that create innovation in this country, then we should oppose this amendment. Thank you, and I yield back.
Gentleman's time has expired. Gentleman from Illinois.
Madam Chair, I yield 1 minute to my friend and the co-sponsor of this amendment, Ms. Waters from California.
Gentlewoman from California is recognized for 1 minute.
Thank you very much, Madam Chair. As a member of the Judiciary Committee, I rise in strong support of the Shark-Born Waters Sensenbrenner Frank's Capture Amendment to strike Section 18. For years, the too big to fail banks have attempted to eliminate their patent infringement liabilities to smaller companies and inventors that have patented financial services-related business method patents. They are now coming to Congress in hopes that you will help them steal a specific type of innovation and legislatively take other financial services-related business method patents referenced in H.R. 1249, Section 18. This is simply wrong. Elected members of Congress should not allow the banks to use us to steal legally issued and valid patents. Financial services-related business methods patents have saved financial services companies billions of dollars, but that's not enough for the banks. Because the banks have failed at every attempt to void these patents, they're attempting to use their power to write into law what they could not achieve at PTO or in the courts. Don't be tricked, don't be fooled, and don't be used. I urge my colleagues to listen to the floor debates. I yield back the balance of my time.
Gentleman from Texas.
Yield 1.5 minutes to the gentleman from New York, Mr. Crowley, who is a member of the Ways and Means Committee.
Gentleman from New York is recognized for 1.5 minutes.
Thank you. I thank the gentleman for giving me such time. Madam Speaker, I rise in strong opposition to the amendment that would eliminate Section 18 of the underlying patent reform bill. Section 18 empowers the Patent and Trademark Office to review the validity of so-called business method patents. This language was drafted in close cooperation with the Patent and Trademark Office and the Department of Commerce. It also enjoys the wide bipartisan support of the Judiciary Committee, which defeated a similar amendment during committee consideration of this bill. Further, this amendment does not hurt any legitimate inventors. It only allows for the review of abstract patents issued since 1998, when a federal court ruled that business methods could be patented, a ruling which the U.S. Supreme Court limited significantly last year. What are these business methods I'm talking about? In one case, a business method patent was issued for interactive fundraising across a data packet transferring computer network. Once obtained, the patent holder sued the Red Cross for soliciting charitable contributions on the Internet, claiming that his patent covers this entire field. In another example, a patent was granted covering the printing of marketing materials on billing statements. These patents and others in this space are not legitimate patents that help advance America. They are nuisance patents used to sue legitimate businesses and nonprofit organizations like the Red Cross or any other merchants who engages in normal activity that should never be patented. In fact, this language will not go after any legitimate patent, only allow a review of the illegitimate patents like those looking to patent the office water cooler discussion. No legitimate inventor needs to worry about a post-grant review, and I submit the rest of my statement for the record. Thank you.
Without objection. Gentleman's time has expired. The chair recognizes the gentleman from Illinois.
Thank you, Mr. Chairman. I yield 30 seconds to my friend and co-sponsor of this amendment, Mr. Boren of Oklahoma.
Gentleman from Oklahoma is recognized for 30 seconds.
Mr. Chairman, I rise today in support of the amendment that I've co-authored with Mr. Schock. During my time in Congress, I have been a consistent supporter of small businesses. Here on the House floor, we are told nearly every day that small businesses are the engine of our nation's economy, and there is no discounting that fact. If included in the final bill, I believe Section 18 will pose a devastating threat to America's small business community. Business method patents already endure a lengthy approval process, and Section 18 would only make it more difficult for inventors to defend their patents. I ask my colleagues to support this amendment, and I yield back.
Gentleman's time has expired. The chair recognizes the gentleman from Texas.
Mr. Chairman, I'll yield the balance of my time to the gentleman from Virginia, Mr. Goodlatte.
The gentleman from Virginia is recognized for 1.5 minutes. 1.25 minutes.
Mr. Chairman, I rise in opposition to this amendment. There is no doubt that the PTO has issued business method patents of questionable merit over the years. Many of these patents are still on the books. Unfortunately, many of these patents are being used by aggressive trial lawyers to extort money from deep pockets. Section 18 of the bill simply creates a process that allows experts at the PTO to re-examine the types of business method patents that the PTO believes to be of the poorest quality. This section was drafted in close coordination with the U.S. PTO and is a pilot program that simply allows them to review certain business method patents against the best prior art in a re-examination process. Why would anyone oppose a process that allows low-quality patents as identified by the U.S. PTO to be reviewed by the experts? Business method patents on financial activities are the type of patents that are the subject of lawsuits and abuse most often. They are litigated at a rate 39 times greater than any other patents. Section 18 is designed to correct a fundamental flaw in the system that is costing consumers millions each year. The provision is supported by a broad bipartisan coalition that includes the U.S. Chamber of Commerce, and I urge members to reject this amendment, which strikes an important litigation reform provision of the underlying bill.
Gentleman yields back time.
Mr. Chairman, I yield back the balance of my time.
Gentleman from Texas yields back the balance of his time. The chair recognizes the gentleman from Illinois.
Mr. Chairman, I would like to inquire about my time remaining.
The gentleman from Illinois has 1.5 minutes remaining.
Thank you. I would now yield 1 minute to my friend from California, Mr. Lundgren.
The gentleman from California is recognized for 1 minute.
Thank you very much, Mr. Chairman. I might just say that in answer to the question raised by my friend from Virginia, why would anybody oppose this? it is because of the Constitution. This provision, Section 18, is clearly violative of the Constitution. It would have you believe that you could go to court, an Article III court, and have a final decision, a final judgment rendered by a court, including a jury, and then after that, not an appeal to an appellate court, but an appeal somehow back to an administrative agency? Does anybody sense there's a violation of separation of powers? Does anybody understand what the court said in the Plout case, which said the Constitution gives the federal judiciary the power to not merely rule on cases but decide them subject to review only by superior courts in Article III hierarchy? You can argue all you want, but that's what the Supreme Court says. This is an obvious, blatant violation of the Constitution. That's the answer to my friends who say we have to have this provision. Yes, it may be that the U.S. Constitution is the inconvenient truth here. We're not allowed to violate it, even though we do it with best of intentions.